Many foreign nationals believe a single global will is the most efficient solution. One document, one jurisdiction, one unified estate plan. In cross-border estates involving Vietnam, that assumption often creates complications rather than clarity. Vietnamese inheritance law operates within its own procedural and substantive framework. Assets located in Vietnam are typically administered through notarial inheritance declarations or, in contested cases, through Vietnamese courts. A foreign will alone does not eliminate these domestic procedural requirements. The issue is not whether one will is legally possible. The issue is whether one will is operationally efficient and enforceable across jurisdictions. These are very different considerations. If a foreign national owns real estate or significant assets in Vietnam, local authorities will require Vietnamese compliance steps. Legalization, certified translation, and domestic inheritance procedures are mandatory. Delays are common when relying solely on a foreign will. Land use rights and residential property in Vietnam are governed primarily by Vietnamese law. Foreign probate judgments are not directly enforceable. They must undergo authentication and, where required, recognition by a Vietnamese court before domestic enforcement. A localized testamentary structure often reduces this additional layer of procedure. A dual will structure involves separate wills for different jurisdictions. One will governs assets in Vietnam. Another governs assets located overseas. Each document operates within its own legal system. Separate wills allow each estate to be administered locally without waiting for cross-border recognition. This reduces procedural friction. It can materially shorten probate timelines. However, dual wills must be drafted carefully. A broadly worded revocation clause in one will can unintentionally cancel the other. This is a common drafting error in multinational estates. Dual wills are not independent documents. They must be coordinated in language, scope, and asset allocation. Consistency prevents cross-jurisdiction disputes. Vietnamese compulsory heirship rules apply to assets governed by Vietnamese inheritance law, particularly a movable property located in Vietnam. A dual will structure allows compliance with these mandatory provisions locally while preserving broader flexibility for assets governed by foreign law. Ignoring this interaction increases litigation exposure. If a foreign national holds limited or low complexity assets in Vietnam, particularly movable assets without anticipated dispute, a single carefully structured global will may be sufficient. However, it must anticipate Vietnamese authentication and inheritance procedures. Simplification should never compromise enforceability. Inheritance tax exposure and reporting obligations differ by jurisdiction. Separate wills can facilitate compliance with local tax authorities. Clarity reduces administrative friction. Foreign investors holding shares in Vietnamese companies face additional complexity. Corporate succession and shareholder agreements may intersect with inheritance planning. Dual wills allow more precise alignment. In multinational second marriages, asset allocation is often sensitive. A Vietnam-specific will can address local property separately. This can reduce cross-border inheritance disputes among heirs. Vietnamese banks and land authorities require compliance with domestic procedures. Presenting a foreign will without local adaptation often delays asset transfer. Procedural predictability has tangible value. Some clients resist dual wills due to perceived complexity. In practice, properly structured dual wills reduce long-term administrative burden. The complexity exists either way. It is better managed than ignored. A dual will structure becomes strongly advisable when substantial real estate is held in Vietnam, when business ownership interests are involved, or when heirs hold different nationalities and reside in different jurisdictions. In these circumstances, procedural separation often enhances certainty. Where assets in Vietnam are limited in value and complexity, where no compulsory heirs create structural constraints, and where dispute risk is low, a single coordinated will may remain defensible. The decision should reflect risk assessment rather than preference for convenience. The decision between one global will and separate wills is not about quantity of documents. It is about enforceability, efficiency, and risk management. Cross-border estates demand structural clarity. If your estate spans Vietnam and other countries, legal systems will not automatically coordinate for you. Your estate plan must anticipate procedural reality in each jurisdiction. For foreign nationals with assets in Vietnam, separate wills are often not duplication. They are strategic alignment. If your estate spans Vietnam and other jurisdictions, the question is not how many wills you have, but whether they are strategically aligned. Vietnamese inheritance procedures, compulsory heirship rules, and recognition requirements operate independently from foreign systems. To determine whether a single global will is sufficient or whether a dual will structure is advisable, contact LTS Law at lts.com.vn for a structured cross-border estate review. In multinational estates, coordination is not duplication. It is risk management by design.